Welcome back, and let's get started. Updating California water laws in the face of droughts and climate change. A little history on this panel. PCL with our legal water advisors from across the state have been engaged in discussions on California water laws and how we should update them for the 21st century. So we really appreciate the hard work that the panelists and their colleagues have put into this effort over the last several years. I want to give a shout out to Jonas Minton, a colleague mentor of mine that passed away this past summer, and he was one of the brain children of this effort. And we had some good successes last year on legislative efforts from this team and their report. So I'll let them speak about the current progress and successes on this next panel. So let's get started. I'm pleased to introduce the moderator of this panel, Matt Baker, PCL Policy Director. And it's all yours, Matt.
Thank you, Howard, and thank you all for being here. Good morning. Yes, the scope of this discussion today is it was largely meant to be an update to the progress being made from the report that PCL published last year, which some of these panelists were involved in the creation of. The report, which the link you should see in the chat, called Updating California Water Laws in the Face of Drought and Climate Change, consisted of 11 recommendations, not all of which we're going to go over today, but just the ones that have moved forward in legislation last year and this year. It consisted of 11 recommendations for modernizing California's water law system for the 21st century. I'm very happy to have these three panelists here today. I originally, when I wrote the panel description some months ago, I really thought it was just going to be an update about the report. But since then, going into the new legislative session, some other important emerging ideas have come forward and are being worked on in the Capitol in the same vein that aren't directly come out of the recommendations of the report. And there's a lot of ongoing, very important water justice work that I also wanted to expand the conversation to include. That is why we have Michael Claiborne here, directing attorney for Leadership Council for Justice and Accountability. We also have Rick Frank, professor of law at University of California, Davis, and Jennifer Harder, professor of law at the McGeorge School of Law. Before I turn it over to each of you for your opening comments, I do also want to stop and give a few words in memory of our late, great water policy advisor, Jonas Minton, beloved personally and professionally in the water world. And I stand here humbly in his place, carrying on this work, and I thank the others that are here. And the other great water mind that we also lost in the past year was Clifford Lee, Deputy Attorney General, that had possibly unmatched depth and breadth of knowledge on water law. And I, before turning it over for your opening comments, Jennifer, Rick, you both worked and were friends with these two greats, and if you would like to say some words, feel free.
Well, I'll be happy to start. Yeah, I've been focusing on water reform efforts thinking about it for a number of years. Of course, I teach here at Davis. And so when Jonas Minton reached out to me and said he was putting together this group at the beginning of 2021 to focus on this issue and make recommendations, I was thrilled, not only because I thought it was a very timely initiative, but also because it provided the opportunity to reconnect with Jonas, whom I've known, known for 40 years. And so it was great to partner with him again, and also with Cliff Lee, who had been my colleague in the California Attorney General's office for over 30 years that I was there, and Cliff was there for 40. And you're exactly right. Matt, that I think Cliff was probably the most formidable, most experienced, most knowledgeable water law attorney practicing in the state of California. And that's a broad and sweeping statement, but it's true. And so we're really distraught due to the loss of those two water giants, Cliff Lee and Jonas Mitten. And I think going forward, and I'm sure I speak for my colleagues on this panel, will be doing so with their memory and trying to continue the good work that they did over the last 2 years. And it's the only silver lining of their tragic passings is that in the last 2 years we had a chance to work closely with them and reconnect with them on a personal level at the same time.
I would echo what Rick has said about Jonas and Cliff. Unlike Rick, I did not have the privilege of working with them extensively prior to this project. I, of course, knew both of them by reputation and had met them on several occasions. This project was my first opportunity to work closely with them, and they both individually struck me as authentic humans who were extraordinarily kind and devoted to mentoring, in addition to being extraordinarily devoted to improving California water policy. And it really was my privilege to get to know and work with them over the 2 years, and very grateful that we were able to accomplish several things. And I, like Rick, am continuing in this effort in their memory.
Thank you so much for that. Yeah, we all recognize that, we're carrying on this work, and, standing on the shoulders of giants before us. And so, yeah, greatly missed. So moving on to the business of the day and carrying on this work, before we get into some of the specific bills and policies that have moved forward in this last year and in the coming year, I just want to open it up for each of you to share your thoughts about, the state of water and water law in California, and where we need to go, and how far away we are from getting there. Rick, I'd like to start off with you, if you wouldn't.
Sure. A few years ago, I wrote an op-ed piece that the San Francisco Chronicle published on this topic, and it was entitled "California Water Law Must Change, and Change Quickly," in light of 21st century conditions. As everyone in this program, attending this program, knows, I mean, California is facing and continues to face a really dire challenge with respect to available water supplies in the time of climate change and chronic drought. And our ecosystem has taken a beating in the process as well. As I tell my students in my water law class, in my opinion at least, we're confronting these 21st century water challenges of climate change, drought, and other factors with relying on 20th century water infrastructure and a 19th century and quite hardened, antiquated, and in many ways outdated water law system. So that is really the problem at a 30,000 foot level. And a number of folks in the water world have been making the same basic point, that the water law system, water rights system, may have worked reasonably well in the 19th century when California had a couple of million people at the most, and there was plenty of water to go around. But fast forward 175 years, and we're now 40 million people with one of the most diverse ecosystems and environments on the planet, and a shrinking amount of available water for the environment, for local governments, and for agriculture and other commercial needs. So the problem from my perspective is that our water rights system is too hidebound, not nimble enough, not flexible enough, and not contemporary enough to effectively deal with these challenges. So I'll stop there.
Jennifer, please share your thoughts.
Thank you. I thank you, Rick. I echo your thoughts, and I want to focus for a minute a little bit more granularly on where I think reform is best. The attention should be focused in reform. And I think we need to be thinking more about the agency that is charged with allocating and protecting our water resources, and to think about the role of that agency in our system. So a little bit about that. The role of agencies generally is not to micromanage on a day-to-day basis. Agencies have a very specific statewide purpose. They assess data, they collect data, they develop a plan, they determine statewide policy to protect the collective, and then they provide space for locals to work within those parameters, and they enforce that system. This is how we operate between agencies and the public. And if I could imagine the most ineffective system possible, it would be a system in which the policies and rules developed by that agency only apply to some and not to others. And yet that is exactly the system that we have in California. So from my perspective, the single most important reform that we need to focus on is to clarify the authority of the State Water Resources Control Board. The State Water Board is the agency that's charged with the broadest responsibility for protecting the state's precious water resources. And I specifically recommend that we focus on ensuring that the water code uniformly provides the board with the regulatory and enforcement authority needed to regulate and enforce over all water rights, regardless of the type of right. And here you'll hear me a little later reference these kinds of rights, so I want to mention them briefly. Riparian rights, rights grounded in ownership of land. Here I'm focused on surface water. Rights that aren't grounded in ownership of land, but depend only on diversion and application to beneficial use. Those are appropriative rights. And for appropriative rights, we have two flavors. Those that predated the Water Commission Act, adopted in 1913, we call those pre-1914 rights. And those that postdated, the post-1914 rights. Of those water rights, the board only has clear, unquestioned authority over the last category, the permits and licenses issued after post-1914. Now, our Constitution in California gives the board regulatory authority over all those rights, but the Constitution is very general, and it, in fact, invites us to adopt laws to implement the authority that it gives to the board. And I think we need to fulfill that responsibility. So what happens with our patchwork system is that although, as Rick mentioned, we have the most exquisite range of ecosystems and species, we also have a world-class economy. We have not given the agency that is tasked with protecting those resources the caliber of authority that it needs to actually do that work. And so our current patchwork system protects none of them adequately, not the environment, not the economy, and it leaves some of our most vulnerable communities without resources. So more to say on that, but I'll leave it there for now and look forward to this conversation.
Thanks so much, Jennifer, for a very valuable historical context. Michael, please share your thoughts.
Morning, everyone. Michael Claiborne. I'm an attorney with Leadership Council for Justice and Accountability. Just a little bit about Leadership Council for those of you who aren't familiar with us or our work. We're a social and environmental justice nonprofit based in the San Joaquin Valley in California. Also work in the East Coachella Valley, and the lens with which we approach our work is all community-based. So we work with approximately 30 communities in both regions. low-income communities of color that are facing a number of different challenges, including challenges related to access to safe and affordable drinking water and safe wastewater infrastructure. So for all of the comments I provide today, I think that's our focus, is trying to get at this problem where it continues to be an issue in California, a drinking water crisis in which over 1 million people lack access to safe drinking water, and we work directly with impacted households and families who lack safe tap water because of pollution problems, because of water supply problems, and because of affordability and the risk of having water shut off if you don't pay your water bill, assuming that you're served by a water system. So in terms, kind of turning to my thoughts on where we're at in implementation of the human right to water, which we recognized in this state in 2012, about a decade ago, I think there's still quite a lot of work to do. As I just mentioned, we still have about 1 million people in California who lack access to safe and affordable drinking water in their homes. It's a problem that disproportionately impacts communities reliant on small community water systems and domestic wells that are groundwater dependent communities. The problems that we see impacting communities we work alongside are pollution problems, natural and man-made pollutants, supply problems, and affordability problems. I'd note also that this is a racial justice issue. You're more likely to be exposed to pollution in your drinking water, to have a dry well or a well failure, and to be at risk of and experience a water shutoff if you're a person of color or a household of color. And that's something that absolutely needs to be addressed. I guess just talking briefly about a couple of the communities we work with and demonstrating the issues of pollution supply and affordability. The first I'd mention is Tullyville in Tulare County. It's a small farm worker community, 2 streets is all in the community, really a small neighborhood, and they've had unsafe water off and on since at least 1978. Nitrate problems were what they've faced for the longest period of time. Since about 2011, they've faced hexavalent chromium in their water as well. And more recently, they've also experienced supply issues when their wells began to fail as a result of overpumping of groundwater in the area. Working on a drinking water solution there that hopefully will solve the problem, and that's interconnection with the nearby city of Exeter. But that's a long-term project, and they're still a ways off for having safe drinking water. And then on the affordability issue, I just briefly mentioned Cantua Creek and El Porvenir in Fresno County, 2 sister communities that we work alongside, low-income communities of color, with many folks working in farm work in both communities. And they have both a pollution problem, unsafe water, and severe affordability problems. El Porvenir, the county, is currently conducting a rate study or considering adopting a rate study that would raise their base rate to $290 a month for a low-income farm worker community, and that's without including the cost of sewer. So I think that clearly highlights the need to address affordability. I think just 4 kind of points around what we see as the solutions. The first is organizing and meaningful community engagement. I don't think we're going to reach any of our goals if impacted communities aren't meaningfully involved in developing and implementing the solution. The second is we need to do much better at source protection, both on the pollution control side and the Sustainable Groundwater Management Implementation Act implementation side. And then drinking water solutions, that could be treatment, it could be funding consolidation, it could be new wells or water supply. We have the funding and legal tools for the most part that we need because of recent action over the last 10 years, but a lot to do on implementation of those solutions. And then lastly, we need to address the affordability crisis in the state. And I know we're going to talk much more about that. So I think I'll leave it there until we get to some current and past legislative efforts.
Thank you, Michael. Thank you all. after we, talk about some of these specific bills that we're all working on, that largely pertain to surface water, I hope that by the end of the discussion, we can circle back to Sigma implementation as well. But I think Jennifer said it well about, giving the Water Resources Control Board, the essential tools to be able to handle the changing conditions that we're seeing and increased drought and, anticipated times of scarcity as we move forward here. That's really what the PCL report was about. The recommendations don't point to blowing up the whole system and starting over. It's really about giving sort of incremental, steps and more tools to the Water Resources Control Board to be able to handle these challenges. And so after publishing the report and it was sort of announced in this space at the Assembly last year, three bills, immediately came, went through the legislature that, were directly related to three of those recommendations. SB 1205, AB 2639, both sponsored by PCL, and AB 2108 was sponsored by California Coastkeeper. 1205, authored by Senator Allen, mandates that the State Water Resources Control Board develop regulations pertaining to how climate change is addressed in assessing water availability for new water permits. Jennifer, could you describe the importance and the implications of that?
Absolutely. Thank you, Matt. So as Matt, as you noted, this recommendation was part of our PCL report, came out of the PCL report. All of the recommendations in the report were unanimously agreed by all the participants. This particular recommendation we referred to colloquially as our no-brainer bill, the one that in a rational world we would obviously adopt. I was very pleased when Senator Allen sponsored the bill and we were in with PCL, and with the entire team's help, we were able to make this reality. So this bill focuses on the State Water Board's water rights program. I talked about those categories of water rights earlier: riparian, pre-14, post-14. Originally, the idea was that we would address the entire water rights administration system, and I still think that is important, but I'll say something more about that in a moment. But as it got narrowed in the legislative process, this bill addresses only the water rights program of post-1914 permits and licenses. And it specifically says that the board has to take climate change into account when it assesses the availability of water for appropriation. So the board goes through a water availability analysis. It must integrate climate change. Now, I want to note here that even aside from this bill, accurately determining water availability as a factual matter is a fundamental obligation of the board as an administrative agency and as an instrument of government. It's required to make decisions that are accurately grounded in facts. And it was our belief that the board has existing authority and an existing obligation to integrate climate change into not only water availability, but into the administration of water rights generally. The reason for this bill really was that the board in reality is underfunded, it's short-staffed, and it's beset by having to navigate competing priorities. So this bill was really focused on giving the State Water Board clear direction as to legislative priorities, and so that it could set its administrative priorities, which is what we ultimately did there. So I guess I would say that it's wonderful that we got this bill enacted. At the same time, I think that as the board thinks about climate change, as it's considering water availability in the permit system, it also should be thinking about integrating the climate change facts into its administration of the water rights system generally, including the extent to which it does have some power over non-permit and license rights, those pre-14s and riparians.
Thank you, Jennifer. Yeah, it was, as you said, even though we all considered it like a no-brainer that we obviously have to go there, it was still a heavy lift to get that across the finish line. And, you know, PCL considers a big victory and a big step forward to finally have that done with 1205. Two other bills that weren't as successful. AB 2639 was a bill that mandated that the board finalize and adopt a plan for the Bay Delta, which is something that has been waiting for a long time. And AB 2108 was a bill sponsored by the Coastkeeper that did get passed in the end. Did improved outreach requirements and equity analyses and board operations, but did the piece that was part of the PCL recommendations that tribal and EJ representation be a requirement for the state and regional boards. That ended up being opposed by the administration and pulled out of the bill, did not make it. And there is still interest in moving that idea forward, but to my knowledge, to this day, there isn't a home for that piece of legislation yet this year. Rick, could you talk about the implications of those two bills?
Sure. Let me start with the really bad news. The proposed update by the State Water Resources Control Board of the water quality plan for the San Francisco Bay and Sacramento San Joaquin Delta, the so-called Bay Delta plan. That plan, which is really critical to the water quality and ecosystem health of the Bay Delta system, was last updated by the board in 1995, 28 years ago. Both the state law, the state water code, and the Federal Clean Water Act and EPA require that California's water quality plans be reviewed and updated on a regular basis. Indeed, federal law, the Clean Water Act, has a proviso that it be done every 3 years. But again, it's been 28 years since the Water Board has come up with a new water quality plan. The most important component for our purposes of which is updating flow standards to protect the Bay Delta fisheries, which are in dire peril and a part of an ecosystem that is crashing and has been for the last several years. In 2018, the Water Board announced a, quote, framework for going forward and updating the plan and acknowledged the, quote, urgent efforts to address the water quality problems and the imperiled fisheries in the Bay Delta ecosystem. But that's pretty much where it ended. The board and Governor Newsom decided to go with a consensus-based negotiation among stakeholders known as the voluntary agreements process, which was undertaken for a couple of years. It was not a terribly inclusive process, in my view, and it stalled. It has stalled. But over those couple of years of that process, which I think is still technically alive, but on life support, the Water Board did not proceed and didn't indicate any particular desire to proceed with the regulatory update of the Bay Delta plan, preferring to defer to this consensus-based process that hasn't borne any fruit. One of our recommendations in our report, PCL-sponsored report in 2022, the beginning of 2022, is that enough is enough, and that the legislature needs to step in and direct within a specific time frame, the water board to follow its legal obligations and update the Bay Delta plan and provide a hard deadline to do that. And the legislature was interested in this, and a bill got introduced, AB 2639, in the last year's session to do just that, to impose a hard deadline of December 1st, 2023, to complete the report by the board and to prevent the board from granting or extending any water rights permits until such time as the plan was completed. That bill passed the Assembly Water Parks and Wildlife Committee. Both Jonas Minton and I jointly testified in support of that bill, and it got out of committee, but it died without ever receiving a floor vote. Last December, environmental justice and tribal groups filed a petition with the US EPA for a rulemaking proceeding that would designed to have the EPA order the state board to update the plan and require in compliance with the Clean Water Act. So that's underway. So speaking only for myself, our group as a whole has not weighed in on this, and PCL I don't think has made a decision, but speaking for myself, I fervently hope that we redouble our efforts to pursue this initiative in the 2023 session. I think it's timely and overdue action, and hopefully we have better chance and prospects in the legislature this year. The second bill, tribal environmental group representation in proceedings, administrative proceedings before both the State Water Board and the 9 regional water quality control boards, is an effort to provide those boards with a commitment to make affirmative outreach efforts to racial minority, disadvantaged communities, rural communities that really lack the resources in many instances to participate in board proceedings that have direct relevance to them. We made a recommendation that happen and that funding be provided to those groups so that they can participate in a meaningful way to cover their travel costs and expenses in order to participate. A bill passed 2108 by Assembly Member Rivas, passed in the legislature, but didn't contain all of the provisions that we were hoping for. And this is not a new concept. Both the California Public Utilities Commission and the California Energy Commission have these programs in place for their own regulatory proceedings and provide funding to facilitate participation by underserved communities and communities of color. So there's a strong precedent here, and it's one that should be followed. So I'll turn it back over to both Michael and Matt to see if they have any supplemental comments on that bill and its prospects and future.
Yeah, please, Michael. Do you have thoughts on 2108?
Yeah, I could talk a little bit about 2108 and then maybe pivot to SB 222, which is a bill that we worked on last year. I think there's some really good components in 2108 and was really happy to see that pass. One of the things that we liked best about that bill in its final form was that it requires the state and regional boards, when they're issuing permits, to consider whether the permit will have any disproportionate impact on environmental justice or tribal communities. I think the simple fact of conducting that analysis, determining whether or not they're making decisions, they being the public boards of those agencies, whether they're making decisions that impact communities of color more disproportionately, will hopefully have a good impact on decision making at the state and regional boards and lead to better source protection. So yeah, that was a very good bill. I think the recommendations to pursue community capacity building is still something that we're very interested in, and would love to see representation for EJ and tribal communities at the state and regional boards in future legislation as well, since that ended up not making it through the process. Another bill that we worked on last year, and actually the year before, it was a 2-year bill. SB 222 was a bill authored by Senator Dodd, and I think the point of the bill was recognition of a fact that at least I find to be self-evident, and that's that if access to safe and affordable drinking water really is a human right, we're not going to recognize and realize that right until access isn't determined by income and water becomes affordable for low-income households. Unfortunately, that's not the case right now. For a majority of water systems in this state, throughout the entire state, so not just San Joaquin Valley and East Coachella, where I work, but also in more urban areas like Los Angeles and San Francisco, and the Bay Area, water is unaffordable for low-income households served by that system. And unfortunately, for most water systems, there is not a social safety net or low-income rate assistance program affordable to assist low-income households. As a result, low-income households are subject to and at risk of water shutoff for inability to pay their monthly or regular water bills. That's an issue that we've recognized in the state for a while. Senator Dodd ran another bill back in 2018. That was AB 401, which required development of a report analyzing how to address the problem, how to provide low-income rate assistance. And I think I actually misspoke. That might have been a 2015 bill. And we ended up with a report from the State Water Board, a pretty good report, the AB 401 report, addressing how to provide low-income rate assistance, how to structure a program to provide assistance to low-income households. And SB 222 was an effort to actually implement those recommendations and establish a statewide low-income rate assistance program to help low-income families with both drinking water bills and sewer bills, and help to ensure that residents don't lose access to what's an essential service because of inability to pay. We got pretty far with that bill. It ended up passing the legislature, which was quite a heavy lift. Had a number of conversations with various stakeholders. And I should mention Leadership Council sponsored the bill along with Community Water Center and Clean Water Action. After it passed the legislature, though, unfortunately, the Governor Newsom vetoed the bill because of lack of funding, with a kind of form veto statement that he passed along with numerous other bills last year, given the prospect of reduced budget, reduced income at the state level in California. So that's a bill that we passed through the legislature, but didn't end up getting signed into law. Absolutely still a priority for us and for communities we work alongside, and something we hope to bring back this year potentially, or in the future.
Well, yeah, so I do want, that's an overview of some of the important legislation that was addressed in last year's session. I want to move now to some of the things that are emerging in legislation related to this work this year. And that's a perfect segue. Michael, why don't you just start off at what is in store for what 222 was trying to accomplish last year? Is there going to be a renewed effort? Would it be changed in any way to address the veto?
Yeah, I think two things. One is that Senator Dodd introduced another bill in December, SB 3, that we're again sponsoring with Community Water Center and Clean Water Action. That bill's quite a bit narrower, and rather than addressing affordability, it would provide additional due process protections prior to a water system shutting off a household for inability to pay. And the background there is SB 998 was a bill from 2018. It established water shutoff protections. It requires basic things like providing notice and offering a payment plan before a water system shuts off a household for a past due bill. So some really common sense protections. The problem with SB 998 is that there's a carve out for small water systems. So it applies to water systems with more than 200 connections. Those with 200 connections or fewer were not subject to the law, meaning residents of small rural communities and or water systems within urban areas like mobile home parks that serve only a few households or up to 200 households are not subject to existing requirements. SP3 would fix that problem and extend water shutoff protections to those served by small water systems. So hoping that's a fairly non-controversial proposal and it makes it through the process. I think we've heard from a lot of residents we work with that they shouldn't be subject to water shutoffs without protections just because they live in a smaller community. So that's something we're trying to address. The broader affordability effort, and to your point, Matt, around addressing the governor's veto message, our focus right now is figuring out how to fund low-income rate assistance in this state. It's a challenge in part because of Proposition 218, which restricts public water systems' ability, at least to an extent, to fund customer assistance programs with ratepayer dollars. And we have, I think, some creative ideas on how to fund that program, but we're working right now with the governor's office to try to get buy-in for an approach and then hope to bring back the policy, which I think was great policy passed the legislature. So in that sense, we're ahead of the game.
That's great, Michael. I hope that's fairly uncontroversial work as well on SB3. I'm going to turn back to the PCL recommendations. There are a couple of those recommendations that are going to be moving forward this year. And then another potential piece of legislation that, you know, PCL and partners are that have sort of is related to this, not directly coming out of the report, but related to this conversation. That first of all, we have Assembly Member Rebecca Bauer-Cahan has authored AB 460, which that is on the books now, just came out this week, which is directly from our recommendation concerning giving the board more powers and authority for interim relief. And that bill is likely going to include some enforcement provisions moving forward too, and thinking about fine increases and some greater enforcement authority for the board in light of some recent things that have happened. Jennifer, can you talk about those two pieces?
Actually, I think Rick is prepared to talk about those two pieces, so I'll turn it over to Rick.
It is Rick. Sorry about that.
Yeah.
Right. Happy to do so. In that, let me provide a little bit of background, and then I'll get to the specific proposals. In that Chronicle op-ed I indicated I wrote some time ago, I referenced the fact that the California's Little Hoover Commission about 8 or 9 years ago published a report identifying the fact that the water board had less financial and personnel resources to enforce its water rights system than it had in the 1960s, which is remarkable when you think about it. And to quote President Abraham Lincoln, with the absence of enforcement, laws are nothing more than good ideas. And an example of that very, very current arose in last year in 2022 in the wake of water curtailment orders that the water board imposed for most of the state in light of the chronic drought, multi-year drought that we had been facing. The Sacramento Bee environmental reporters, Ryan Sabelo and Dale Kassler, both of whom have unfortunately retired from the Bee, which is a big loss. Their last story, published in November of 2022, was entitled, headline, "Troubled Waters, California's Regulatory System is Unprepared to Address California's Chronic Water Shortages and Its Ecosystem." And that story profiles the misadventures of farmers and ranchers in Siskiyou County who have traditionally diverted water from the Shasta River for their agricultural and ranching opportunities. And they decided, to put it bluntly, to ignore the board's curtailment order and proceed with the diversions they wanted to make from the river, and in the process dewatered about 2/3 of the flow of the river with the attendant adverse environmental, ecosystem, and fisheries impacts. That story shone a bright light on the problem and the enforcement deficiencies when it comes to the board's enforcement powers and administration of its water rights system, because the farmers and ranchers were quoted. They acknowledged it was the fines and penalties that they were facing were, no pun intended, drop in the bucket compared to the profit they could make on their agricultural activities. It just wasn't a deterrent to them to violate the law. But even before that, a very unfortunate event, our working group was concerned about problems and defects in the board's enforcement authority, particularly focused on so-called interim relief. When there's an urgent problem of a violation of the water code, courts have the ability to provide interim relief in the form of granting the board a temporary restraining order or preliminary injunction while the merits of the case play out. But unfortunately, the board in its administrative system doesn't have that interim relief authority. As it is under the status quo, the board, before it can pursue an enforcement order, it has to conduct a hearing process, which takes time and gives violators of the water code and water law a lot of time and running room to continue their illegal activities, and that doesn't make sense to us. So, as demonstrated by the Siskiyou County misadventure, the board needs those kind of authorities to act nimbly. And also, as demonstrated by the B story and what happened in Siskiyou County, while this wasn't one of our 11 working group recommendations, we came to the conclusion that the board's penalties system and the maximum amount of administrative penalties they can impose on violators of the water code and water board orders are too minimal. So we are in 2023, to get to Matt's request directly, proposing and supporting legislation to bolster the board's enforcement authority, both by granting the board interim relief power in its administrative proceedings, and to increase significantly the financial penalties, administrative penalties that the board is authorized to assess and under the bill that Matt referenced, AB 460, by Assemblymember Bauer Kahan, the chair of the Assembly Water Parks and Wildlife Committee, the board would be empowered to assess administrative fines of up to $10,000 per day for each violation, and in addition, $5,000 for each acre foot of water diverted illegally or without authorization from the board. So that bill it just introduced on Monday, and I believe the PCL has taken a strong position in support of that bill. So those are two efforts which our working group at least strongly supports to enhance and strengthen the board's water rights enforcement authority.
Yes, Rick, I mean, more than support, PCL has agreed to co-sponsor the legislation along with other members of the salmon and steelhead coalition, including California Trout, who I know we have some people here with us today on, and have been also been a leader on this enforcement issue. Another bill that we are hoping to sponsor is a bill that is directly related to our recommendation on enhancing powers of permit verification for the board. Senator Allen is considering this proposal very strongly, and we're hoping we'll finalize a decision to move forward with it here soon. Jennifer, can you explain that proposal?
Absolutely. Thank you, Matt. So this proposal is central to the idea of addressing the board's fractured authority. The idea is that the board should have the authority to ensure that all water users are diverting and using water according to valid water rights and diverting and using water within the scope of those water rights. It's a fundamental task for a board challenge that's tasked with administering a water rights system. At a minimum, the board should be able to make sure people are working within their water rights. If you have a pre-14 or a riparian user that it doesn't have a valid right or is diverting and using water outside the scope of their rights, then they are encroaching on someone else's water. That water may belong to another water user. It may be water that should be dedicated to the environment or held aside for health and safety reasons. So it's foundational to ensure that these users have valid rights and are staying within the scope of their rights. Surprisingly, the board's authority to take these actions is not clearly stated. There are a number of existing authorities under which the board might assert such authority, but the language isn't clear. And there's a really pernicious effect when you have language in the code that is unclear or even in some cases contradictory about the board's authority. It allows for the threat of litigation, which creates the potential for delay, for expense, and for confusion that causes bad negative results later where decision makers are confused about what the law actually is. And the potential for that litigation actually implicates negotiating power and political power in the process. And it's really important, as we've talked about the importance of our water resources and the board in its role in managing these resources, that we don't allow poorly written laws to create political power and negotiating power and unnecessary expense and delay where these things should not exist. So when we think about the board's existing authorities to ask people to identify the basis for their water rights and how they're diverting and using water so that the board can verify that that's all legal, the board only has a handful of tools to do that. And each of these tools, as I mentioned, are flawed. For example, one provision of the water code gives the board the ability to investigate stream systems, to conduct investigation of stream systems. This particular provision doesn't clearly say that the board can investigate riparians and investigate pre-14s, which creates the pernicious effect of that threat of litigation and the assertion of political and negotiating power. Likewise, other provisions of the water code give the board the authority to adjudicate rights on a stream system. Now, that section does expressly reference pre-14s and riparian rights, but the board isn't allowed to initiate the adjudication. It has to come from the water users, and the adjudication itself can't focus on a particular water user to the exclusion of others. It has to decide all the rights in the system, which is infamously a lengthy, expensive process that can take decades to resolve and doesn't actually solve any problems. So the verification proposal would fix this problem by simply giving the board this clear authority to say, hey, do you have a legal water right? And hey, are you using water within the scope of that water right? This is a very basic, rational provision. The verification proposal would also give the board or it would assign the burden of proof in that process to the water right holder, simply because, again, thinking rationally and simply, the water right holder has the best information about their water rights. If you live in a home and someone says, hey, do you really live here? You're the one that has the deed, and you're the one that can demonstrate that you live there. Likewise, the water right holder should have the burden of proof in those processes. So that's the verification in a nutshell. Really hoping it goes forward.
I do too, and I'm really excited that I think we are going to get this moving this year. The interim relief and the permit verification powers were, the two top priorities that came out of our committee, and I'm happy to see that. I think we're going to have homes for both of them. An idea that has emerged since last year, and since the publishing of the report, that a lot of people are interested in is seeking a legislative fix to a recent 6th appellate court decision called the curtailment cases decision. Jennifer, could you also explain what was problematic about that decision and what we're seeking to try to do to fix it?
Yeah, I'm happy to. This gets a little bit into the weeds, so I'll try to keep it at a high level. But essentially, when we refer to the concept of curtailment, what we mean is that, let's think about those water rights I talked about previously: riparian rights, pre-14 rights, post-14 rights. In California, those water rights are have the right to access water according to a priority system. Generally speaking, if you're looking at all three rights together, riparians have the most senior priority, and then pre-14s and post-14s in order of when they first diverted or filed their water right application. So its priority essentially means first in time, first in right. So curtailment is the idea that when there's not enough water to go around, water right holders are supposed to reduce their diversions consistent with their water right priority. Historically, this process has been self-policing. The water users were expected to just do the right thing and stop diverting when we had droughts. In recent droughts, it's been clear that we needed that state manager in to say, hey, here's how much water is actually available in this water system. Here are all the water rights in that water system with their respective priorities. So given this amount of water available and given these water rights, here's who on that list no longer has access to water until it starts raining and snowing again, right? This is actually how our water rights system is supposed to work. It's foundation of how water rights work. It's not taking away anybody's water right. It's just, we're just implementing the system we have, but the board is stepping up to do that because the individual users don't have access to the information and how it all works in the system from their silos. So the board attempted to implement these curtailments and has been sued in a couple of cases, actually. In one of those cases, the board's actions were upheld. That was the Stanford Vina case. And that case predated the case I'm about to talk about. In the second case, the appellate opinion was issued in 2022. As Matt mentioned, it's called the California water curtailment cases. The issue in that case focused on the board's curtailments from 2014-2015. So not the most recent curtailments. And in 2014-2015, the board had relied on a particular provision of the water code to implement the curtailments. That provision of the water code contains some language. Remember, I mentioned earlier the pernicious effect of unclear language, which said that the rights that were subject to that section were rights that were authorized in that division. So it had this language which could be interpreted, didn't necessarily need to be interpreted, but could be interpreted to exclude riparian and pre-14 rights and only include post-14 rights. In fact, prior to the curtailment cases, there had been a number of important cases recognizing that this language didn't limit the board's authority over riparian and pre-14 rights. Those prior cases recognized that the board had authority to bring individual actions against appropriators under this water code provision. And I'll just give it a number. It's 1052 is the provision I'm referring to. That the board could bring individual enforcement actions for using water outside the scope of their rights, or when they have forfeited water, for example, by not putting it to beneficial use, and any other number of transgressions that was recognized under the common law. However, in this 2022 case, California water curtailment cases, the 6th District Court of Appeal found that allowing the board to rely on 1052 to regulate the use of water between an entire group of water users, not an individual water user, but an entire group, was a step too far, according to the court, in light of this language authorized in this division. Now, let's leave aside the legal nuances of how we might address the reasoning in that decision. From a practical matter, this ruling creates a mess, because when one uses water outside their priority, that is definitionally using water outside the scope of their right. It's just, if you're exceeding your priority, you're outside the scope of your right. And if the board can't tell a group of people at once how everybody is supposed to be using water, then there's no practical way for the board to enforce the water rights system. It becomes wholly impractical. So, to its credit, the 6th District Court of Appeal recognized that these prior decisions had created approved the board's ability to go after individual water users, and said, we do realize that saying that the board can go after individual water users, but can't go after a group all at once to manage to regulate, if they're within their priority or not, makes no sense. So the court said, but that's not our job as the court to fix. It's the legislature's job to fix. And so what we're doing with this curtailments cases fix is taking the court up on that suggestion and fixing this problem that is created by the pernicious effect of this unclear language in the water code. Let's fix the language and let's make the system work. That's the basic idea.
Thank you, Jennifer, for into the weeds and technical, but very clear explanation of why that's so important. Going back to all of your opening comments, I mean, I think we all agree that there is a long way to go and a lot of work to do in this area. But I'm really excited about the pieces of legislation that we do have moving forward this year that we've talked about so far. And so far, my conversations with our partners and with legislators and committee staff around these pieces of legislation, there's a lot of appetite for this work in the legislature this year, more than ever, I think. People realize that we have to modernize our water law system, or our people that lack safe access to water, and for the environment, and there is a lot of interest in doing this work this year, and I'm excited about what the possibilities are for this year moving forward. I do want to start opening it up to audience questions. I have some more questions myself, but I urge the audience to start putting your questions in the Q&A. I have one from Reggie Collins at California Trout. I don't know if the panelists have their Q&A open. You can read this yourself, but I'll go ahead and read it out loud. Reggie says, I agree with your assessment that the water rights system remains outdated, especially with respect to the equity imbalance associated with the establishment of riparian appropriative rights that only afforded property ownership to a select few. We do, however, have some underutilized tools. For example, Fish and Game Code 5937, public trust protections, and actual water rights enforcement. How do we expose this antiquated system, utilize the existing tools, and build a coalition that has the political ability to make these changes? How do we influence the governor's office, legislature, and expose this imbalance? So I open up to any of you who have thoughts on that. It's kind of a big one.
Well, I can start out. I don't want to be too critical of the legislature because, one of the key flaws of our water rights system was that until about 50 years ago, the environment and environmental interests were not at the table. They didn't have a role there. The role of the environment and the need of water for environmental values, fish and wildlife, was not recognized. So incrementally, even though in California, unlike many other states, the environment can't request a water right, an appropriative water right permit in the same way that that consumptive water users can. Nonetheless, the legislature has incrementally, piece by piece, provided ways to reserve amounts of water or allow traditional water rights holders to grant or transfer some of their water to environmental values. So there's some tools in the toolbox that exist to provide recognition of environmental concerns and to make some water available for environmental values. But at the same time, in times of chronic drought, like we've been facing in California for most of the last 20 years, the first cuts are to water for the environment, and it is environmental values that have been hit and damaged the hardest. Going back to the questioner's goals, there is, of course, the very powerful constitutional provision, Article 10, Section 2 of the Constitution, often overlooked by water users, but a voter initiative from 1926, I believe, that basically said that all water use in the state must be reasonable and can't be excessive. And we have court decisions saying that what is reasonable can vary with the location, with the circumstances, and with the era. So it's a flexible standard. And the public trust doctrine, which the California Supreme Court explicitly applied to water rights in California in the iconic Mono Lake decision, National Audubon versus Superior Court, remains a very powerful tool and is not limited, as Jennifer has alluded to in some cases, to permitted appropriative rights, but applies to all water rights in the state, as does the Article 10, Section 2. So there are tools available. The tools may not be adequate to the task. Again, part of our working group's efforts has been to seek out those key deficiencies that needs to be fixed. And for those of you who are not familiar with the report, I commend it to you for the recommendations, which is a starting point. It's not an end point. And we've talked about this morning some proposed initiatives of our working group and hopefully the PCL organization as well to correct some additional deficiencies like lack of robust enough administrative fines that we can move forward on going forward.
Thank you, Rick. And I want to turn to Michael for the other part of this question. But before, I just got news from Senator Allen's office that they have crossed the permit verification proposal in SB 369 just minutes ago. So that's exciting. We've got another good bill out there. But Michael, as a fellow advocate in this space, what about the political and coalition building part of that question? Are we? I feel like we're getting better and more unified on these issues. What's your perspective?
Yeah, I think that addressing the part of the question about how we influence the governor's office, legislature, and expose the imbalance. I think from our perspective, effective advocacy at the legislative level is generally I almost said always, in our experience, always community-based. So if impacted communities and residents aren't leading a campaign, it's just much less likely that that campaign or legislative effort is going to be successful. So I think that's the biggest thing from my perspective, is real meaningful community engagement, and kind of following the lead of local leaders in impacted communities and driving solutions. So I think that's one point. I think the other point that I have less expertise in, I think, is communications. Professor Frank mentioned article in the newspaper in the Sacramento Bee. I think that's another thing that we need to do a better job at, is telling the story of why these legislative solutions are necessary, and what the problem is, what the fixes are, and why the existing legal framework isn't working and is leaving communities and households behind. I think there's much more we can do there. I do think things have improved in the last few years. I think some really good press has come out of LA Times, Sacramento Bee, San Francisco Chronicle, just to name a few. But there's more to do there as well.
Jennifer, thoughts on this question?
Yeah, I would agree with my co-panelists here. The general principles that Rick mentioned, reasonable use, public trust, all of the other tools that the board has, those tools are part of our system. But the pernicious effect, not to be a broken record, of lack of clarity and the potential for litigation, political power, negotiation power, all of those things lead to underutilization of those tools. And after looking at this for a while, my first best recommendation is, let's shore up the State Water Board authority to make it clear that it can use these tools whenever it needs to, and that it has the enforcement power and the penalties that it needs. Make the system work. We already have the outlines of the system. We need to clean up a few things to make sure it works as it should. The other thing I want to say is that it's important, I think, to recognize that in this effort, it is not necessarily environmental interests and vulnerable communities against water users. A functioning system benefits all water users. The water users, although some of the more politically positioned of them have resisted a strong state board over the years, I think more of them, more in number, more in terms of water use, would benefit from a strong state board. And it would increase the efficiency of how they do their business, and it would reduce their transaction costs in the long run. So I think it's important to everybody to be talking about these reforms in a way that makes it clear that if we adopt these reforms, we will have an administrative system of the caliber that we should have in a state like California, with such a beautiful environment, important recreation, right? Communities we need to care for, and a strong economy. Everybody benefits.
And if I could just supplement on one thing, talk a little bit about water politics. It's, back in I'm old enough, I remember in the 60s and 70s, it really was environmentalists against the world with agricultural users, municipal users. So they really didn't have a seat at the table, either in terms of political influence or administrative proceedings or the like. That has changed. And I think in many ways, environmental groups, environmental organizations can and in the future can ally with particularly municipal water users, and depending on the local governments, there's a lot of enlightened leaders and doing a lot of innovative things to preserve water values, because they realize that recycling water and conserving water is good for municipal finance. It's also good for the environment on which their thriving communities depend. So there are partnerships and alliances, and another long overlooked interest group when it comes to water politics has been Native Americans. We have more Native American tribes here in California than in any other state, and it's part of the sad history of Native Americans in this country that their water rights have often been ignored. There's a major case before the U.S. Supreme Court right now involving the Navajo Nation and its rights to Colorado River water. And I think those rights and the legitimate expectations and needs of Native American communities, not just in California, but throughout the country, are being increasingly recognized by other water users and water decision-making bodies like in California, the State Water Board. So I think that is progress.
Thanks for all of your thoughts on that. I mean, yeah, I think there's progress, and like I said before, and still a lot more work to do. I'm just trying to review. If you look in the chat, we just got another question here. Kimberly Burr. Maybe more of an observation. Thank you for that, Kimberly. I wanted, like I said at the beginning, I would like to, I'm talking a lot about surface rights. I would like to go back to the Sustainable Groundwater Management Act, SGMA, a little bit. And, you know, I believe the law was passed, correct me if I'm wrong, 2015.
14.
And all this time, the individual basins have been, you know, developing their individual groundwater sustainability plans, a lot of which are going to start being published this year and moving forward. Michael, I know you're really close to this. You know, what are your thoughts on the status of SGMA implementation?
Yeah, it's a big question. So I think I mentioned earlier that most of the communities we work with rely solely on groundwater for their drinking water supplies, for their tap water supplies. Only a couple of exceptions, and those are Cantua Creek and El Porvenir for the most part, in terms of small community water systems that are currently relying on surface water, and they're in the midst of a project to switch to groundwater. So the vast majority of folks that we're working with are relying on groundwater supplies. And unfortunately, it's still the case that the big water users in the San Joaquin Valley in particular, at least in particular as to where I work, are overpumping groundwater resources to the extent that we're seeing every year during a drought, thousands of wells, hundreds or thousands of wells go dry. We expect, unfortunately, that to continue under the San Joaquin Valley groundwater management plans, the groundwater sustainability plans. We've engaged in the process of developing local plans now for the last several years, trying to improve those plans, trying to get groundwater sustainability agencies in the San Joaquin Valley to address overpumping of groundwater, prevent overpumping to the extent that it causes dry wells. And at the local level, at least, we've faced a lot of resistance and haven't had a lot of success in strengthening those plans. There's two parts of SGMA. Part of it's local control. So that's the part that we're already through, at least for the priority basins. The other part is state oversight. And that's where we're, I think, we're pretty close to an answer on whether Department of Water Resources is going to play a strong regulatory backstop role and ensure that SGMA is actually protective of groundwater supplies, actually requires sustainability, and doesn't allow wells to go dry. I'd say right now, I'm fairly optimistic that Department of Water Resources is taking its role in SGMA seriously, and that we'll get, unfortunately, some inadequate determinations in the San Joaquin Valley for groundwater sustainability plans. I say unfortunately because I would have liked it if the local GSAs had done a better job and protected groundwater resources, but we are asking for inadequate plans because of what we've seen and analyses that we've done that show that in the San Joaquin Valley alone, if these plans are implemented, up to 12,000 wells, domestic wells, will go dry. That's just not a situation where mitigation is going to be perfect if you allow that many wells to go dry. I know there were some recommendations in the report around well mitigation, which we absolutely support and we've been pushing for. At the same time, even if the funding's there, we've had a really, really difficult time in the valley replacing dry wells. Self-Help Enterprises is the primary nonprofit that has state funding to contract to replace domestic wells. And they have about 1,800 wells backlogged in their system right now that they're trying to replace, that they have funding for, but they can't get drillers out fast enough to address either the backlog or wells as they go dry. And in fact, at their current pace, Self-Help is estimating their backlog will take 16 years to address, and that's if no other wells go dry. So I think from our perspective, what we've got to do is stabilize groundwater levels. This just isn't sustainable. It's not equitable. So a lot of work to do. And like I said, I think I have some optimism the state is willing to do that work, along with some concerns that if the state does play an effective regulatory role, we'll see increasing litigation around groundwater rights and potential adjudications, which I have a lot of other thoughts on, but I'll stop there.
Can I offer some quick additional thoughts, Matt?
Sure, sure.
In the run-up to the passage of SGMA, I was someone who was hoping and advocating that the responsibility for state oversight would go to the state water board. Would seem to make sense in terms of their role over groundwater and surface waters otherwise. But that said, politics is the art of the possible, and the legislature saw fit to give that authority, that oversight authority, to DWR. And I agree with Michael. I've been pleasantly surprised that DWR seems to be taking its regulatory oversight role quite seriously, which is good because DWR historically has not been a regulator. So it's new to them, and but they appear to be showing good judgment and backbone in rejecting a number of the submitted groundwater sustainability plans by local agencies as being incomplete or inadequate. So that's important. But I think there's a critically important role for environmental organizations such as the Planning and Conservation League and its constituent members to stay vigilant and to participate and advocate for their interests. And the one that Michael has talked about, domestic wells going dry, primarily but not exclusively in the San Joaquin Valley, in the Salinas Valley, Sacramento Valley, and other places as well. That's a critically important constituency. So I would encourage all the folks involved that are watching this to go back to their organizations and neighbors and continue to play an oversight role to ensure that DWR continues to show some backbone and oversee SGMA implementation. It's going to be critically important in the coming years.
Jennifer, thoughts?
On this point, I would absolutely underscore the points made by my co-panelists, and I would offer that it is first really important to continue pursuing legal fixes that would establish clear standards for when these wells need to be protected. Michael mentioned the report recommendation for well mitigation. There are more great ideas out there that we should be pursuing about how to protect these wells. The other thing, putting on my water professor hat for a moment, I wanted to underscore is that there are existing authorities that would protect these wells. Article 10, Section 2, the human right to water, and SGMA, if you take all of these three things together, establish a legal principle that we need to protect these wells. It has not yet been taken to court and clarified by a court, but I believe that authority is there and that the opportunity to make those arguments is out there. So I would encourage people to continue thinking about those issues.
Great, thank you. I have a follow-up question on that, but I'm going to go back to Kimberly's question in the chat and clarified what that question was. I mean, she was making the observation that it seems a shame that it seems to be fully reliant on the public and community environmental groups to police the water rights system, but she's offering that public agencies could have a greater role in this too, and is positing the question, what more can public agencies do to support each other and the control board?
Well, I think at the state level, which is the level of government I'm most familiar with over the course of my career, I think it's important that that the state agencies involved in this process do communicate with one another through regular contact and interagency working groups. You've got the water boards, state and regional boards. You've got the Department of Water Resources. You've got the Department of Fish and Wildlife. And I think in this climate change challenge time, there are other agencies that are being given increased responsibilities for climate change concerns, including a number of those within the umbrella of the Natural Resources Agency. So I think it's government works best when it works in an integrated fashion, and we don't have a bunch of siloed agencies. And I think to Governor Newsom's credit, he's continued a tradition we've seen from the previous two governors of putting good and effective and committed leaders in the environmental leadership posts in the state government. And I think in general, they have worked well together over the last decade or two, and hopefully they will in the future.
Yeah, I mean, just offer my thoughts. I mean, I feel like this is a challenge across all sectors of government, and certainly not just the issues around water. Same challenges and questions would be very appropriate for our transportation agencies that often, there's a whole report about the lack of coordination between our various transportation agencies at times, and I think that the state, I think there's ample room for thinking about how to improve coordination across agencies, thinking about mechanisms that allow agencies to have joint powers, authority in implementing policy. Yeah, I think there's a lot of room there. We are pushing up on time. I really want to thank all of you for your time today and your insights, and I'm privileged to work with you all, and I'm excited about the work ahead this year. And if you have any closing thoughts, please share.
I would just like to say that I am so excited to hear that the verification bill is moving forward. And I want to thank Senator Ben Allen and PCL for all the work that you're doing on that important issue. Best news all day.
Yeah.
And somewhere Jonas Minton and Cliff Lee are smiling and gratified that we're continuing on this work, which they helped commence. And Jonas especially showed the vision to put this group together. And I'm delighted to still be able to collaborate with the rest of you folks and move this process, this movement. It really is a movement forward in water reform.
I think the only thing I'd add is I think this was a really interesting panel, and I enjoyed the conversation. I think there's absolutely a ton of work to do, but I do have some optimism in part that we're going to be able to address these problems because so many good people are working on them. So I appreciate the opportunity to join the conversation.
Thank you all.
Yeah, thanks everybody. I concur with Matt that years of PCL doing this at the legislature, there definitely seems to be an appetite more now for obvious reasons. But I think there's also more of an appetite, in the public to really dive into this. And I think all of your work and all of this integrated collaborative work we're doing is showing that more and more people are kind of taking notice as they should and as we should, right? So I think this is a great opportunity. The timing is right. These are very large initiatives, heavy lifts. This is not easy work, but we so appreciate, all of your involvement in it. And a lot of the people I can see on our attendee list that are helpful allies and partners as well. So this definitely takes all of us to make this happen. I'm very excited about the positive news, Matt, and thank you, Rick and Michael and Jennifer today. Appreciate your time. So just to wrap up here on our last session, this was the last of our series of our assemblies. Thanks everyone for joining us. We've had a wonderful series of panelists and thought leaders sharing their insights and experiences in this wide array of subject matter over the last 4 weeks. And it's all linked to extreme measures. We at PCL, the policy committee, our legislative and legal advisory teams, we all are kind of focusing on how we can help solve, mitigate, and affect change in dealing with our climate crisis. And we do that in land use, in water, in transportation, in housing, in ecosystems, and wildlife. So all the topic sets that we work on, we really try to focus all of our policy priorities on how do we help solve this climate crisis and the impacts of those. So appreciate everyone's support on that. We couldn't do this without our sponsors. So thank you to all of them, especially to our gold and silver sponsors, Canton Brown, Carsons and Minter LLP, National Wildlife Federation, Sage Sweetwood, and Shoot Mahali and Weinberger LLP. Their sponsors make this panel, this assembly and all of our panels work. So that's